right? Actually, you have a story about that, don't you? About protection and advocacy?
The student, or me back in the day when I was a hippie.
Will you tell that story? I love that story.
Actually, this was before I obtained my master's in social work. I worked at the private nonprofit psychiatric rehabilitation center, and I had, I guess, what some might describe as more of a hippie aura in my presentation of self. I would, had long hair down to here, and I would put it up in a scrunchie, and I was, Birkenstocks, long maxi dresses all the time. And my boss really wanted to promote me, but he just had to have to sit down with me and say, look, I can't promote you if you present like that. Now, people won't take you seriously. What you do in your personal life is your personal life, but when you come to work, if you really want a promotion or you want to move up, you need to change the way you present 9 to 5. When you're doing work, because it's a perception. When you go up, it's just the way that it is. And this is a hard thing for me to hear as a revolutionary. Being 23 years old and being self-supporting since I was 18, and really being a part of what I felt was a culture at the time, to be told that people in social work have judgments about the way that I look and present myself, that just doesn't seem right. But I had to reconcile with that and accept it. And it was probably the best piece of advice that was ever given to me as a 23-year-old. Because I did change, and now I've made I even have a PhD too. So, it's really helped me get where I want to do and create change in positive ways. But I don't think I would have got there if he would have ever told me what people really thought about the way I came in every day. And to give you guys some perspective, 2 weeks ago, we did our annual training for all of your field instructors. So we had probably about, 200 field instructors come to our field instructor training. We presented on topics and, policies and procedures. We had some guest speakers. And at the end of the day, I had a couple field instructors come up to me who, I have a good rapport with them. I know them pretty well. I've been doing this for a while. And the first thing they said to me, how do you get your hair like that? I was sitting there and I was looking at your hair and I was just thinking, you look like Audrey Hepburn with your hair like that. And I was thinking to myself, this is a great example, even as professionals, how we're up there, we're talking about all these professional things, and I'm sure there was people there looking at my shoes, what color I had my toes painted, how I got my hair like this, it's gel and hairspray, little butterfly clips, in case you're wondering. And that's just part of being in a professional culture, is always being mindful that people are always looking at you and how you present. Okay, and the last thing I wanted to talk about, because I get a lot of this stuff forwarded to me, and then I have to respond to it, is emails. If you guys are sending emails, number one, please, please, please don't use text language. Do you know what I mean? You, it's not a letter, it is. But in an email, it should be Y-O-U. I actually got an email last week from a student that said TTYL. Okay. Okay. So you guys really need to make sure that you guys are writing your emails to your faculty, to staff, to your field instructors, to anybody within your field organization in a professional manner. Dear Mr., Mrs., I can tell you one of the most important things, guys, spell their name right. If you don't know, call. If you don't know, look it up. You guys should see how my name has been spelled. I think somebody actually wrote McGargle the other day, as in gargle, G-A-R-G-L-E. I give them credit for that. That was creative. So make sure, you guys, that you're because it really sets a tone and how they're going to think about you and how they're going to perceive you. Make sure you're spelling their name right. The other thing is, be cognizant of the tone that you're setting in your email. Okay? Because if I'm having a dialogue with you face to face, you can tell how I'm responding to you based on what? Yeah, my facial affect, my tone, my body language. But in an email dialogue, you don't have any of that, right? So sometimes it's really hard to tell what somebody's sentiment is, right? So if you send an email to me that says, all in capital letters, immediate response needed,
what do I assume? That you're dying. That you've been harmed. That you have some major life crisis. Okay? And then I open the email, and it says, I can't find the timesheet online. Do you think that that subject line matched your message? No. And to give you guys a heads up, your faculty don't appreciate it. Okay? They are genuinely invested in you and concerned for you. So if you send them an email that says, important, immediate, need response, they may be on vacation. They may be at a conference. They may be in a meeting, and guess what? They're going to open that email. And are they going to be happy when they read that you want an extension on your paper? No. Okay? So just be really mindful of what you say. How many of you guys have gotten emails from me? Okay. How many of you guys got, I hope you had a good day. I hope you had a good weekend. Thank you so much. Take care. Call me with any questions. How did you guys feel about me before coming here today? Or even meeting me in person? Anybody? How did that email set the tone for how you feel about me? That I was open? That you could talk to me? Anybody else? That I cared? That I cared too, right? Now, if you had gotten an email back from me that said, I need this immediately, Jen, how would you have felt about me? I might get it faster, 10 points, 10 points. Yeah, it's an approach, but I use that example because I'm always very mindful, of how I communicate with you guys via email. Because you're brand new, you don't know a lot of the answers. I may be, or Melissa may be, one of the first people you actually physically talk to in the college, because you apply online, you get accepted online. Everything's so electronic nowadays. We've kind of lost the human touch. So that's just something to keep in mind. Let's say you're in your field placement, you have to send out emails to other people on your team. How many of you guys in here are going to be part of a multidisciplinary team? Probably even more of you. You just haven't gotten there yet. If you have to send an email out to your team, right? It's going to set a tone on how they feel about you. Now let's say, for example, oh, I forgot the email signature, let me get to that. But for example, at my first field placement, I was part of a multidisciplinary team. We had the geneticist, child psychiatrist, child psychologist, and the social worker. And each one of them had interns. And the social work interns were kind of viewed as the bottom of the totem pole, right? I wasn't a child psychology intern. I wasn't getting my PhD. They kind of looked at us like, oh, you're the social workers. Yeah, you go do that assessment. You go help that family. So was I not only representing the university, the College of Social Work, but I was representing social work as a profession, right? Just something to be mindful of, guys, that it's a lot more going on in your organizations than just you and your individual dynamic with your field instructor, okay? And then lastly, I was going to wrap up with email signatures. Here's my sentiment. Have somebody read your email signature. Does everybody know what I mean by email signature? A lot of people have quotes, famous quotes, inspirational quotes. It can get dicey, right? Because how many of us in here have our professional set of beliefs and values? And how many of us have some that are different, some personal, right? And that's okay. But when you're sending out emails in a professional context, you don't want anything that can be viewed as political, maybe religious in nature, right? So here's my sentiment. Avoid them in your professional dialogues, or if you decide to use one, have a couple people look at it and ask them what they think. Because I've actually had 2 field instructors this year call me, and they were concerned about the email signature that a student had, And I had to have a dialogue with that student about that. Not that it was appropriate or inappropriate, but I had to have that dialogue from the perspective of how that student gets perceived. Okay? So, any questions anybody wants to throw out at me about professional presentation? Yes.
I had 3 things that I'd like your advisement on, and I'll probably have to follow up with where I'm interning, but I wanted to return to the phone voicemail message. I don't use a personal message. I use the general with my name. Do you think that's sufficient, or should I change it to a personal message?
That's a great question. I probably skipped over that. Voicemail message. It's always best to either have the pre-recorded, you have reached 443-5555, right? That's a safe bet because they know they got you. They know it's you because they said your number. Or, hi, you've reached Jennifer. I'm not available right now. Please leave me a message and I'll get back to you as soon as possible, okay? If you have a voice message, I've actually called a couple of you in this room over the summer. And it was like, hi, it's me, thanks. Who? Who did I just call? I don't know who I just called. And then you probably got a very funny voicemail from me. Hi, it's Jennifer from the College of Social Work, okay? So if you guys have a personal voicemail recording, you may want to make sure that it's clear, it indicates that they've reached you, and it's professional in nature. Okay. Did you have another question?
I do, yeah. Thank you. It's a Facebook-related question. Do you think it'll be appropriate to join the network of where we're interning, and how much? Could you just talk a little bit about how much distance we should keep from?
That's a great question about Facebook and your professional organization. We're actually going to get into that a little bit later when we talk about boundaries and what professional boundaries mean. So I'm not going to get into a lengthy dialogue about it. But basically, my sentiment is to shy away from being Facebook friends with people at your organization, because guess what? We just had a great conversation about professional presentation, right? This is my professional presentation. But guess what? When I go home, I like sweatpants and big sloppy t-shirts. And I like to walk the dog, right? I have a totally different version of myself when I go home. And guess what? When you become Facebook friends with somebody, you openly invite them into that other part of your life. And guess what happens when you openly invite people into stuff? Then they have opinions, right? And then it kind of blurs the lines a little bit, doesn't it? How many of you guys have had that happen? You Facebook friend somebody because they sent you the request and you're like, oh God, they sent me a friend request, what do I do? Well, I guess I better accept it because I don't want to be rude. And then how many of you had gone, I wish I never accepted that friend request, okay? Okay, so you guys know exactly what I'm talking about. Okay, last question.
Okay, yeah, the last thing has to do with email. Sometimes I like to open with a little bit of like banter, just to...
Like witty banter?
No, not witty, just like, oh, it's a great day in Columbia. I don't know, just to kind of set the tone.
Yeah.
And then sometimes people are real direct, like one sentence, maybe not even a closing or salutation. So how should
my suggestion is if you guys want to be a little bit friendly in nature, not be friends, but be friendly in nature, because there's a difference. We'll talk about that later. I always start with really simple stuff with you guys until I get to know you. I hope you had a great weekend. I hope you had a great holiday. Can you believe all this rain? Hope you got some sunshine where you are. Okay? Simple, basic stuff like that is always safe. Always safe.
But not witty.
But
I'll speak to that because I'm Veronica.
I'm one of those that doesn't do salutations and things like that a whole lot. And I guess I'm kind of staying on the border with that kind of stuff because you don't see humor in emails. You don't see tone in emails, and unfortunately sometimes we make think we're funny. I'm one of those that tries to be funny, but I just can't pull it off a lot. So I've had to learn to really just scale it back. Not that I've ever really tried to anyway. I've not ever been known for my humor, but some people think they are. And that's something that we have to learn about ourselves, that we may think we're funny or being witty, but there are people like me who may not think it's funny, or other people. So I would just err on the side of caution until you understand who you're communicating with. I think it's just always, you know how Jennifer talked earlier about work culture? I would just be in the role of the observer the first semester and just really take into account what your environment is like and who folks are before you do something that might offend someone. Because once you offend someone, it's hard to repair that relationship. So I would just always err on the side of caution. I think there's some general duties, but I don't think there's any right or wrong. I mean, I think if people get to know your personality, they're going to expect, you know, a fun opener and that sort of thing. But I would just probably hold off until you have that rapport with them first. With that being said, we're going to pick up with expectations after Clifford, so we're going to come back to some of this. But we have a very important guest speaker with us today. He is an attorney at law. His name is Clifford Scott, and he consults and works with us on a regular basis. I don't know what I would do without Cliff. I consult with him a lot of times. He is general counsel here at the University of South Carolina, and he is with you all today and with us to talk to you about HIPAA and any other questions that you might have. So without further ado, I'm going to hand it over to this wonderful man and let him talk to you and engage with you about some of these legal things that you need to consider as you embark in your field of practice.
I don't know who the wonderful man she's talking about, and I'm here. So. And I'll just tell you, if you haven't had your morning coffee yet, I'm not here. December ain't the most exciting time. I'll try, but I can't promise you won't fall asleep. I'll just ask those of you who are sitting next to me, if you see the nod, if they start to do it, just I'm one of 5 lawyers who work in the Office of General Counsel, the Tim Perry, Mr. General Counsel, and the full rest of the minions who work for him. As Melissa said, we do have applications that occur on a regular basis. You'll find out when you get into the field. I'm sure that just looking, not that I'm implying anything by this next comment, but you can't hear me? Okay. How about now? Is that all right? Okay. Not implying anything by this comment, but I'm looking over the audience. Some of you are probably experienced in the field. Is that safe to say? Some of you don't have quite as many gray hairs as I do, and some of you get kind of close to it. And some of you are almost competing with me for not having any hair at all. So I feel safe to say that some of you probably have been out in the field already and will probably, hopefully not be bored by what I have to say, but will probably be more familiar with what I have to say than some of the more, shall I say, less seasoned members of the audience. Is it okay if I close this?
Absolutely. That's okay, we'll put it back.
Okay. All right, so just by show of hands, how many folks have actually been out in the field working in the area? I'm just curious. Okay, so a fair number. So y'all would probably have to deal with HIPAA, correct? Probably on a regular basis, probably more often than you might think about. HIPAA, I regard HIPAA as nothing more than a common sense approach that the federal government decided to take back in 1996. Actually, this act was HIPAA, which HIPAA stands for, by the way, for those of you who aren't familiar with it, the Health Insurance Portability and Accountability Act. That's a mouthful, popularly known as HIPAA. It was enacted actually on August 21st of 1996. So today is HIPAA's birthday. Yeah, today's HIPAA's birthday. And you know, Melissa, I remember last year I spoke on HIPAA's birthday too, as I recall.
I know. It's all for HIPAA. It's on page, we have the information about HIPAA on page 69 if y'all want to follow along.
And by the way, my presentation probably will not track what Melissa has given you, because I've just made some notes here summarizing the highlights of it, and also I'll be talking to you about some new changes that took place, which are effective as of 2013. But anyhow, in 1996, Congress decided, in its infinite wisdom, to catch up with most of the states, because most of the states already had laws that protected information, and HIPAA was enacted by, well, some of the states. HIPAA was enacted in '96 to establish a federal, if you will, a national law that protected health information. And if I had to summarize HIPAA as simply as I could, I would simply say that HIPAA requires you to keep your mouth shut, to mind your own business, and to protect the business of your patients and clients. And that's it in a nutshell. So, any questions? I'll fill in some blanks for you. But really, when you think about it, that's really what HIPAA is telling you. Keep your mouth shut, mind your own business, and protect the business of your clients and patients. That's really what HIPAA is about. HIPAA was enacted to cover what we call protected health information. And protected health information is essentially any information about an individual that can enable you to, well, actually, I'm just going to read it to you. Protected health information is any information concerning an individual's past, present, or future health condition or treatment, or the payment, past, present, or future, about an individual's health condition or mental condition for treatment. And that can include any number of things. It can include an individual's name, an individual's date of birth, social security number, address, any information that can be used that would enable anyone to identify who it is who's being discussed is considered to be protected health information. So, someone discussing with a colleague in the hallway who doesn't have a need to know information about a particular client or patient and doesn't name the client or patient, but talks about a 45-year-old man with blonde hair who has a condition, that's a violation of HIPAA unless that person has an absolute right to know, even though the person's name was not discussed. And by the way, HIPAA applies to any form of the information that's possessed by the covered entity. That is electronic, hard copy, that is papers, or oral information. And of course, the example I just gave you involved the exchange of information orally. That is, in fact, a violation of HIPAA. Now, with respect to disclosure of HIPAA information, the regs say that you can disclose protected health information anytime it's permitted by the regs or required by the regs. Well, what does that mean? Permitted by the regs or required by the regs? Well, when is it permitted to disclose health information, protected health information? Anybody? Who said payment of services? That's correct. Anybody else?
When the person poses a danger to another human being or something.
Well, we're getting into some of the categories. That's right. Well, first and foremost, you can always release protected health information when the patient authorizes it. If the patient authorizes it, you can always disclose the information. But there are other circumstances during which or in which the information can be disclosed without the patient's information. Forgive me, authorization. For instance, to provide treatment. If you go to a doctor's office, or if someone is a social work client, and it's necessary for you to refer this client somewhere else for services, you wouldn't necessarily need to get the person's authorization in order to refer information about the patient or the client to this servicing agency. So providing treatment is one example of an instance in which you would not have to get the patient's authorization. Payment. If a provider of treatment submits information to a health insurance carrier in an effort to receive payment for providing treatment to that patient, the authorization of the patient is not required. I don't see any nods, people nodding off here, but I see some bleary eyes and they want to get that cup of coffee. Tell me it's not the most exciting topic. So, providing payment, providing treatment for healthcare operations. What does that mean, healthcare operations? those of you who raised your hands, I just kind of want to get an idea, what kind of organizations did y'all work in? Hospital, DJJ, where else? Group home? School, okay, all right. Well, for those of you who worked in hospitals and even large doctor's offices, you're aware that those institutions, those agencies sometimes conduct what we call quality assurance and risk management activities. In other words, they will review the types and the nature of treatment that their doctors or nurses or other healthcare professionals have provided patients to make sure that they're doing the right thing and that they don't get slapped with a lawsuit. So they'll conduct quality assurance assessments or risk management assessments to limit the extent to which they may be exposed for inappropriate health care provided to the patient. In those instances, when they pull the records and start reviewing them, they don't have to get the patient's permission to do that. And by the same token, Medicare and Medicaid have their hands in just about everything with respect to health care. And on a regular basis, Medicare and Medicaid will conduct audits of healthcare records, and they're not required to get the patient's permission to do that. So those are just some examples of instances in which the patient's authorization is not required. Public health activities. For instance, if someone is treated for a disease that poses a potential for contagion, in other words, for the disease to be spread throughout the populace, the hospital or the doctor's office may contact THAC, Contact Centers for Disease Control, and is not required to get the patient's permission to do that. And you'd understand why. Let's see. What about instances involving anybody? You said you worked for DJ. Who worked for DJ? You did. Okay. What did anybody work for DSS? Okay, several people work for DSS. Have any of you who work for DSS had to deal with instances involving allegations of abuse or neglect of either vulnerable adults or children? And DJJ too. Okay. In those instances, do you have to get the patient's or client's permission? That's absolutely right. Another category in which you can release or disclose information without authorization is when you are required by law. And you're required by law to report allegations of child abuse or neglect of vulnerable adults. So you are required by law to do that. So in those instances, obviously, you're not going to be required to get permission of the individual who's covered, whose information you're disclosing. I'm a lawyer and I deal with the judicial system. Typically, we will see instances of subpoenas or court orders being issued requiring the release of medical records. Medical records that contain, that's the quintessential private or protected health information. And you're not required in those instances to get the permission of the individual. I had a case, I have several lives. In one of my other lives, I was prosecuting a case involving a juvenile. Well, actually, how old was this juvenile? Actually, he wasn't juvenile, he was 17. But he committed a very adult act. He committed a sexual assault with a 9-year-old. And as a matter of fact, he was very sexually active himself, and it resulted in the 9-year-old contracting venereal disease. And so, in order for us to establish that he, in fact, was the perpetrator, we wanted to get a copy of his medical records, because around the same time that the child reported to her mother the symptoms which resulted in the mother taking the child to the doctor, the perpetrator also went to a healthcare provider and was treated for venereal disease. So we subpoenaed the records, and we got the records through subpoena and court order. I also requested the court to order the records from the appeals to restore us to us. Well, obviously, we didn't have to go to the perpetrator and say, hey, would you mind us getting your records? We want to prove that you did what you're accused of doing here. We didn't have to do that. The judge gave us permission to get the records. So in instances when the court will order a release of records, or back to what we talked about earlier, the statute, the laws requiring the permission, I should say the disclosure of information, the authorization from the patient is not required. Let's see. I can continue to go down this list of examples here when you're not required to get permission, but what I'd like to do is maybe touch on some of the changes that took place in 2013. As many of you who have worked in the field know, if you release information without authorization, or if you release information and one of the exceptions doesn't cover the release, you're subject to being sanctioned. What do I mean by that? That means you're subject, or your employer, the agency you work for, is subject to being hit for a fine. Under the old rule, if you released information that was improperly released, your employer could be subject to a fine of $25,000 per hit. So if the information was disclosed improperly, your employer could be subject to a $25,000 fine, which means you probably wouldn't have a job after that. Under the new rule, it's double. The new rule, and by the way, these new rules were effective as of March of this year. Under the new rule, it's now $50,000 per hit. So this, I mean, the federal government takes this very seriously. Under the new rule, each violation is subject to a $50,000 penalty. And that means it can be anywhere from $0 to $50,000. But they are very serious about this. And in fact, in the new regs and in the new legislation, HHS, the Department of Health and Human Services, makes clear that its Office of Civil Rights, which is the enforcement arm for HIPAA through HHS, it makes clear, in fact, they stated, we're going to be much more rigorous in enforcing HIPAA. And so, please, whatever you do, take this seriously. Like I said, it's not the most exciting topic, but the Department of Health and Human Services does take it seriously. And you can understand why. In this day that we live in, everybody has got a potentially HIPAA violation device on their hip or in their pocket. And you can access all sorts of information. Now, I'm aware of people actually taking pictures, it's stupid that they do it, of people's records with cell phones. Now, why would you do something like that? Like I said, everybody's carrying with them in their pocket around their hip a potentially HIPAA violation device. So you have to be careful about that. And believe it or not, and Melissa, I don't know if you were here when this happened or not, but when Jim was working with me.
That's a good story. I would tell them that. Because sometimes I think we know HIPAA, but we don't when it comes to situations.
Right. A former student actually posted online information describing a patient's condition and other demographic information, but didn't use the patient's name. Did not use the name. But like I said, any information that can be used that would lead a reasonable person to be able to identify the individual is a violation of HIPAA. And now, it doesn't take rocket science or the genius of a rocket science to realize you ain't supposed to be doing that kind of stuff. That doesn't make any sense. And why this person did that, I have no idea.
And they were terminated.
Yes, they were.
They did that.
You talked about this incident already, so you're aware of this, okay. So, yeah, so I mean, you can't do that. I mean, that's ridiculous. That doesn't make any sense at all. And, luckily, no fine was imposed as a result of that. But, if given the right client or the right patient who screams long enough and loud enough, a fine can be imposed. Under the old rule, the presumption was, it's a release, okay, well, we're not going to worry about it unless there is a significant risk of harm to the patient's finances or reputation. So under the old rule, you were presumed innocent. You're presumed innocent under the old rule. So under the old rule, if a violation or breach occurred, you didn't have to report it. That is, the covered entity didn't have to report it unless the covered entity believed there was a significant risk of harm to the individual concern's reputation or finances. Okay? So you presume innocent under the old rule. Under the new rule, you presume guilty. You're presumed guilty. Like I said, the fines have increased and you're presumed guilty. So what that means is, under the new rule, if a breach occurs, let's say, for instance, you're working in a hospital and you're working with patient administration or release of health information, and you are asked to mail a copy of an MRI report to a child's parent. Let's say you're asking. I don't know if this is a realistic example or not. But in the process of mailing it, you get distracted, you get a phone call, and instead of punching in 639 Oak Street, you punch in 691 Oak Street. Okay? And it goes to somebody else. So there's a record out there that's going to somebody else, and you discover it after you go back at the end of the day and you're looking through the work you did, and you see the address that's on the screen on the envelope that you prepared, and you say, "Oh my God, what have I done?" Well, under the old rule, you're presumed innocent, and unless you can establish under the old rule that there was a significant risk that anyone's reputation or finances would be affected by that, you didn't have to report that. Under the new rule, you're presumed guilty. The breach is presumed to have resulted in harm, unless the entity can establish that there is no potential significant risk of harm to the reputation of the entity. How do you do that? Well, the entity itself, in this instance, the entity itself, the hospital itself, has to go through a four-pronged